So, we have a massive development today in the nationwide legal fight over suppressors and short-barreled rifles, and this one is not small, procedural, or technical. A federal judge has just granted a nationwide preliminary injunction that goes far beyond anything we've seen before. This isn't just blocking the enforcement of the $200 tax, we already had that. This order actually halts the enforcement of the NFA registry itself for suppressors and SBRs while this litigation plays out. Let me say that again so it sinks in. The ATF has been ordered to stop requiring registration for these items nationwide, effective immediately. Now, before we get into what this actually means, if you like following real-time legal developments like this, make sure you're subscribed and hit the like button. These cases move fast, and I cover them as they happen, filing by filing. That like button tells the algorithm that this constitutional content matters, and it pushes it to more armed scholars who need to see it. Here's why this is exploding right now. The legal foundation that the NFA stood on for nearly a century has started to crack. Not because of a Supreme Court ruling, not because Congress repealed it, but because of something much quieter and much more technical. Congress quietly reduced the $200 making and transfer tax on suppressors, short-barreled rifles, short-barreled shotguns, and other NFA items to $0. That single change is what started this entire avalanche, and once the tax goes to zero, the question becomes, what exactly is the government still allowed to regulate? To understand why this injunction is different from every other injunction we've seen, you have to understand the distinction between the tax and the registry. Historically, the Supreme Court of the United States upheld the NFA not because it was a firearms regulation, but because it was considered a taxing law. The court said Congress could require registration, paperwork, and restrictions because it was all tied to enforcing a tax. The NFA survived for decades on that reasoning. Not the Commerce Clause, not public safety, taxation. So once the tax becomes zero, multiple Second Amendment groups and plaintiffs across the country filed lawsuits saying something very simple. If there is no tax, there is no taxing power. And if there is no taxing power, the registration and transfer scheme cannot legally exist. That is the legal theory now being tested in court. But here is the trap that the ATF and the DOJ have been trying to spring ever since that law passed. They said, okay, fine, the tax is zero, but the registration requirement, that stays. You still have to fill out the Form 1 or Form 4. You still have to wait months for approval. You still have to fingerprint. You still have to register your firearm like it's a machine gun from 1934. And the plaintiffs looked at the DOJ and said, on what constitutional basis? Because the registry was incidental to collecting the tax. You cannot keep the registry attached to nothing. That is a regulatory scheme without constitutional authorization. Now here's where this gets interesting. The government is trying to defend the registry and enforcement system by saying, even though the $200 tax is now zero, the NFA registration system still helps enforce another tax, the SOT tax on manufacturers and dealers. In other words, they are arguing that the entire nationwide registration system for millions of lawful gun owners is still justified because it indirectly helps them monitor a business tax paid by licensed manufacturers. That is the argument. And the plaintiffs are saying that is a massive stretch, one that the Constitution simply does not allow. And the judge just looked at the DOJ's arguments and essentially said, I don't buy it. And furthermore, you are likely to lose at trial. Now, I need you to understand the procedural weight of what just happened. A preliminary injunction is not a final ruling. It is the court saying, based on what I see right now, the plaintiffs have a substantial likelihood of success on the merits, and if I don't stop this now, they will suffer irreparable harm. The irreparable harm part is what the ATF always fights. They always say it's just paperwork, it's just registration, it's not a physical deprivation of property. But the judge here accepted the argument that being forced to register a constitutionally protected item under an unconstitutional law is itself irreparable harm, because you cannot unring the bell. Once your name is in that registry, it is in there forever. That is harm that money cannot fix. So the judge said, stop, nationwide. No registration required while we sort out whether the entire NFA framework for these items is still alive. This is not just about the tax anymore. The tax is already zero. This is about whether the ATF gets to keep the black book of every suppressor owner in America when the legal justification for that book has evaporated. Now let's talk about what this order actually says, because there are nuances that are going to become battlefields in the next 48 hours. First, the scope. This is nationwide. This is not a plaintiff-specific injunction. This is a universal injunction preventing the ATF from enforcing the registration requirement against anyone in the United States for these specific items, suppressors, SBRs, SBSs, and AOWs. That is massive. Second, the judge explicitly rejected the DOJ's SOT tax argument. The judge basically said that is a bridge too far. You cannot regulate millions of law-abiding citizens and their private property just to make it easier for you to audit a limited number of federally licensed dealers. That is using a sledgehammer to swat a fly, and the Constitution does not allow that. Third, and this is the part that the DOJ is absolutely seething about right now, the judge set an expedited briefing schedule. This case is not going to languish for 3 years. The motions for summary judgment are now on a rocket docket. Here's where the DOJ's argument completely falls apart. What the plaintiffs did was brilliant. They did not argue that the NFA was always unconstitutional. They argued that the NFA became unconstitutional the moment the tax went to zero. This is called a facial as-applied challenge based on changed circumstances, and it completely neutralized the government's historical precedent defense. The DOJ came into court waiving cases from 1937 and 1939, saying, "See, the Supreme Court upheld the NFA, case closed." And the plaintiffs said, "Those cases upheld the NFA as a taxing statute. They did not uphold the NFA as a registration statute disconnected from taxation. You have changed the nature of the statute by eliminating the tax. You cannot rely on precedent that addressed a completely different legislative scheme." The judge agreed. And this is where it gets really uncomfortable for the DOJ, because the judge cited the Obamacare case. The plaintiffs flipped that logic on its head. They said, if a penalty that looks like a tax can become a tax for constitutional purposes, then a tax that has been reduced to zero and generates no revenue can cease to be a tax for constitutional purposes. Let me read you a direct line from the order. The judge writes, "When a tax rate is set at zero and no revenue is collected or expected to be collected, the exaction is no longer a tax in any meaningful constitutional sense. It is instead a regulatory penalty attached to a registration requirement. That is a landmark statement." Now, the DOJ tried to get cute with their SOT tax argument, and the judge called their bluff. The plaintiffs pulled the ATF's own numbers from the very declaration the DOJ tried to sneak in at the last minute. The plaintiffs said, "You are telling this court that you need to subject millions of law-abiding citizens to a permanent federal registry in order to catch potential SOT compliance issues? That is not a reasonable fit. That is not narrowly tailored. That is using a nuclear weapon to kill a mouse." And the judge agreed. But it goes deeper than that. The plaintiffs also pointed out that the SOT tax itself is not even a tax on the items, suppressors and SBRs. The SOT tax is an occupational tax on the business. It is a license fee. The ATF does not need a Form 1 or Form 4 with the registrant's name, address, fingerprints, and photograph to verify that a dealer paid their SOT. They could simply audit the dealer. They could check the SOT roll. They could do 100 different things that don't involve creating a searchable federal database of every American who owns a politically disfavored piece of hardware. So the judge looked at the DOJ's argument and said, in essence, "You have not shown me why the registry is necessary for SOT enforcement. You have only shown me that it is convenient, and convenience is not a constitutional justification." This brings us to why the court is taking the irreparable harm argument so seriously. The plaintiffs came prepared with expert testimony on the chilling effect of registration. They brought in historians who testified about how registration schemes have historically been used to facilitate confiscation, not just in the United States, but in other common law jurisdictions like the UK and Australia. They argued, and the judge accepted, that the act of being forced to register a constitutionally protected item is itself a dignitary harm. It is the government saying, "You may own this, but only if you submit to our surveillance." And here is the key line from the order. "The right to keep and bear arms includes the right to acquire and possess arms without first obtaining the government's permission, particularly where the permission-granting process is untethered from any valid exercise of enumerated power." That is a direct shot across the bow of the entire NFA licensing apparatus. Think about what that means. If the right to keep and bear arms includes the right to acquire without permission, then the entire Form 1 and Form 4 process, the wait times, the fingerprints, the photographs, the responsible person questionnaires, all of it is presumptively unconstitutional when applied to items that are in common use. Now, I can already hear the questions. Does this mean I can just go buy a suppressor cache and carry from my dealer? Slow down. Let's think like attorneys, not activists. The injunction blocks the enforcement of the registration requirement. It does not erase the NFA from the books. The law still says you need to register. The law is just currently unenforceable because a federal judge said it's likely unconstitutional. What does that mean for your local gun store? It means your local gun store is now in a very difficult position. The ATF is enjoined from enforcing the law against you, the end user. but the dealer still has an SOT, the dealer still has an FFL, the dealer still has to answer to ATF compliance agents who might try to find other ways to punish them. Some dealers are going to treat this like past injunctions. They're going to say, if the judge says it's blocked, I'm transferring suppressors over the counter with a 4473 and nothing else. Other dealers are going to be more conservative. They are going to wait for a definitive ruling from the Fifth Circuit or the Supreme Court. My advice, do not be the test case. Do not be the person who buys a suppressor cache and carry and then posts it on social media while the ink is still wet on the injunction. Give it 72 hours. Let the trade associations issue guidance. Let the DOJ file their inevitable emergency stay motion. Because they will file an emergency stay motion, I guarantee you right now there is a career DOJ attorney skipping lunch, typing furiously, trying to get this to the Fifth Circuit by close of business today. And that brings us to the Trump DOJ's dilemma. The DOJ now has a decision to make. Do they appeal this injunction aggressively? Do they ask the Fifth Circuit, one of the most conservative circuits in the country, the circuit that gave us Bruin, to overturn this pro-Second Amendment ruling? Or do they quietly not? Because here is the dirty secret of government litigation. The DOJ is not required to appeal every adverse ruling. They have prosecutorial discretion in litigation just like they have prosecutorial discretion in criminal cases. If the political leadership at Maine Justice decides that defending the NFA registry for suppressors is a losing battle, and frankly, an unpopular battle with their own base, they could simply let this injunction stand while they reevaluate their position. The calculus has changed. Attorney General Pam Bondi is now in charge at DOJ. Where does she stand on this? Does she sign off on an aggressive defense of the NFA registry, or does she quietly let the litigation play out without throwing fuel on the fire? Think about the position the Trump DOJ is currently defending. They are currently defending the position that Americans should be forced to register their firearm suppressors and short-barreled rifles in a federal database, submit fingerprints and photographs, and wait months for government permission, even though the tax that justified all of this has been eliminated by a Republican Congress. Does that sound like something the current administration wants to stake their legacy on? The institutionalists at DOJ will fight it. Career attorneys will threaten to resign. There will be leaks to the press. But the decision ultimately belongs to the Attorney General. Here's what likely happens next. The DOJ has approximately 3 procedural weapons in their arsenal right now. First, the emergency stay motion. The DOJ will file a motion with the district judge asking him to pause his own injunction pending appeal. That motion will fail. It is almost a formality. The real fight is at the Fifth Circuit. Second, the administrative stay. Before the DOJ even files their full emergency motion, they may ask the Fifth Circuit for an immediate administrative stay. This is a temporary pause that lasts about 7 to 10 days, just long enough for the court to consider the actual emergency motion. Administrative stays are granted far more often than full stays. I would estimate there is a 65 to 70% chance the Fifth Circuit grants an administrative stay. Third, the full stay pending appeal. The DOJ will ask the Fifth Circuit to freeze the injunction for the entire duration of the appeal, which could be 6 months, 9 months, maybe longer. To get this, the DOJ has to show that they are likely to win on the merits. And here is the problem for them. The merits of this case are terrible for the DOJ. I put the odds of a full stay at about 40%, slightly less than even, but here's the big picture. This injunction, if it holds, does not just affect suppressors and SBRs. It establishes a principle. The principle is a $0 tax is not a tax. It is a regulatory mandate disguised as a tax, and Congress cannot use its taxing power as a pretext to create a national gun registry. If that principle takes root, what happens to machine guns? What happens to destructive devices? The NFA covers those too. If Congress ever zeroed out that tax, or if a court says the tax rate is irrelevant, what matters is whether the statute is actually collecting revenue, then the entire NFA framework for all Title II items is called into question. This is why the ATF is fighting so hard. They know that if the registry falls for suppressors, the dominoes start falling all the way down the line. This is no longer just a Second Amendment case. This is becoming a case about how far federal power can stretch once its original constitutional justification disappears. Because if the court rules that Congress cannot keep a regulatory machine running after the tax disappears, that principle could apply to far more than just the NFA. And the judges know that. That's why the tone of this case has shifted from firearms policy to constitutional limits. This case is forcing the court to answer something that hasn't been tested in nearly 100 years. What happens when the constitutional foundation of a federal regulatory system quietly disappears? Because the Supreme Court upheld the NFA specifically as a tax law. not as a general firearms regulation, not as a public safety measure, as a tax. So if the tax is now zero, the court has to decide whether the rest of the structure can stand on a completely different justification. That was never the original basis. And that is a very uncomfortable question for the government. Let me address something that is going to come up. People are going to say, this doesn't matter. The Supreme Court will never strike down the NFA. It's too old. It's too established. I want to push back on that with two words: historical tradition. In Bruin, the Supreme Court said that modern gun laws are constitutional only if they are consistent with the nation's historical tradition of firearm regulation. So let's apply that test to the NFA Registry for Suppressors and SBRs. In 1791, when the Second Amendment was ratified, was there any law requiring citizens to register their firearms with the federal government? No. In 1868, when the 14th Amendment was ratified, was there any law requiring citizens to register their firearms with the federal government? No. In fact, the first federal firearm registration scheme was the NFA itself in 1934, and it was upheld solely as an incident of taxation. There is no historical tradition of registration for registration's sake. So if the taxing power justification collapses, and the judge here has said it likely has collapsed, then the NFA registry becomes a historical orphan. It has no ancestors. It has no pedigree. It is a 20th century innovation that does not map onto any 18th or 19th century analog. That is a fatal vulnerability. Now let me give you practical guidance. If you have a suppressor pending in e-forms right now, do nothing. Your application is already in the system. The injunction does not automatically approve it. It simply means the ATF cannot constitutionally require you to wait. But the ATF processes forms slowly on purpose. They will drag their feet. You will likely still wait. If you are about to buy a suppressor, this is where it gets complicated. If you trust your dealer and your dealer is willing to transfer the suppressor over the counter with a 4473 and no Form 4, you have to understand the risk you are taking. The DOJ may get a stay. The Fifth Circuit may reverse, and if that happens, you are now in possession of an unregistered NFA item with no approved Form 4 in the system. Here is my recommendation. Wait 72 hours. Let the emergency stay motion play out. If the Fifth Circuit denies a stay and the injunction remains in full force, you have much stronger cover. If the Fifth Circuit grants a stay, you dodged a bullet. As of this recording, the ATF cannot require registration for suppressors or SBRs. They cannot deny a transfer because you didn't file a Form 4. They cannot prosecute you for possession of an unregistered NFA item if that item is a suppressor or an SBR, because the requirement to register it has been enjoined. The question is not if these items become effectively deregulated. The question is when and how messy the transition is. The NFA is a 90-year-old statute that was built on a constitutional foundation that no longer exists. The foundation crumbled the moment the tax went to zero. Everything else is just the debris settling. As soon as the court issues its next order, this situation could change very quickly. I'll keep you updated as this develops. If you found this breakdown helpful and you want to follow this case as it unfolds, make sure you're subscribed, hit the like button, and keep an eye out for the next update. This nation was built by armed scholars, and it will be maintained by armed scholars.